Alrighty, well, thanks so much for hopping on with us today. Really excited to bring you a great guest. We have Mick Misra from Coleman Greenberg Business Law. And in the M&A side of our business, we work with Coleman Greenberg Business Law on a number of deals, and they have expertise when it comes to M&A law for MSPs in particular. So we're really excited to have Mick join us today to go over some of the frequently asked questions we have about the legal aspects of M&A deals for MSPs. So Mick, thanks for hopping on with us today.
Yeah, thanks for having me, Devin.
Mick, thanks very much, as Devin said, for joining us. This has been sort of a long-awaited session here. We've had many questions that have come up, and Devin and I were talking and said that we should probably do a webinar on this topic and see if we can add value to those both on the buy side and sell side. And so we've come up with some questions for you, and we're hoping that you can demystify this. I think one of the things that is important for us all to say, less so for you, Mick, is that we are not attorneys and we are not providing legal advice here. So, you definitely want to check with your own attorneys on your own situations, your own circumstances as to what's right for you. But nonetheless, there are some questions that we tend to get that are let's say, common or repetitive, and we thought it would be good to cover those. Can we just talk a little bit about the differences between an asset transaction and a stock or a share transaction? Because this is sort of your first fork in the road, if you like, in doing a transaction. And certainly from our perspective, the vast majority of transactions are done as an asset transaction for a variety of reasons. But just maybe your perspective in terms of why would one want to do one over the other? What is the difference for those that aren't familiar? And again, looking at this from both a buy side and a sell side.
Sure. So thank you, Heartland. And I think that's a great topic to start from here. And just to give background is I personally do probably one M&A deal every month or every other month. And so it's a big part of my practice. And it's, through that experience, I've been able to kind of see, the universe of what's going on here. And I think, they all do fall into the two categories that you talk about, either an asset sale or an equity purchase. Now, what's the difference? So an asset sale is really when the purchaser purchases the assets of the target company. So it doesn't purchase the target company itself, it only purchases the assets. And then similarly, what I would say is an equity purchase is when the purchaser purchases the equity of that target company and not solely the assets. And when you look at kind of an equity purchase, it can take various forms. So it can take the form of a stock purchase if it's a corporation. It can take the form of a membership interest purchase if it's a partnership or LLC, et cetera. So there's a lot of different forms that could be used, but they ultimately come down to two categories, which are either an asset sale or an equity purchase. Now, some of the differences is in an asset sale, you mentioned that the majority of what you've seen, probably the vast majority, have been asset sales. And that's because purchasers really drive these transactions. They kind of set the rules and create the terms when there is a deal. And obviously that changes depending on the negotiating power of the parties, but in general, that's the case. And so purchasers tend to prefer asset sales. And there's really two kind of reasons for that. The first is a legal reason, and the second is a tax reason. So from a legal perspective, when a purchaser purchases the assets in an asset sale, it only purchases particular assets that it actually wants. And then it only takes on specific liabilities that it specifically chooses and lists out in the purchase agreement. And so what you avoid in that situation are kind of unknown liabilities that might come. So if they were to purchase the entire equity through a stock purchase agreement, a membership interest purchase agreement, if they were to purchase the equity of a company, they would get all of the hidden liabilities if there are any. And so hidden liabilities could be potential lawsuits, for instance. It could be liabilities that are not included in the balance sheet if they're financial liabilities and other things. So purchasers, typically for the purpose of knowing what they're buying, they prefer to structure their transactions as an asset sale. The second benefit to them is the tax benefit, which is that in an asset sale, the purchaser will get what's called a stepped up basis on the assets. So what that really means is that the seller, the target company, its assets, it purchased it sometime in the past, and say it purchased its assets for $100. Over time, that company takes depreciation on that, and the basis by the time of the purchase might actually be $50, let's say, at the time of the actual deal. But if the purchaser does an asset sale and they pay $100, they're going to get a stepped up basis, meaning the basis of that asset in the hands of the purchaser is $100. It's not the $50 that it was. So that's the big benefit for the purchaser in terms of taxes. Now, kind of the opposite is the case for the sellers. Sellers typically would prefer an equity purchase, and one of the reasons, the legal reason for that is that in an equity purchase, they get rid of the whole company, and they don't have any liabilities kind of lingering around that they have to take responsibility for. And then secondly, for them in a stock sale, let's say, they get capital gains treatment on the sale. So that makes it a simple thing. And it also generally the capital gains rate is lower than an ordinary income tax rate. And there could be other aspects that are beneficial to the sellers in an equity sale. For instance, if the owner of the assets is a C corporation, then there's going to be basically two levels of tax. There's going to be a tax when the C corp sells the assets, and then there's going to be another tax when it either liquidates and distributes cash to its owners, or it doesn't liquidate and distributes cash to its owners. So there's definitely tax aspects that are detrimental to a seller. And so what happens in these cases is if I'm representing the buyer, I typically will want an asset purchase rather than a stock purchase. And there are some exceptions to that, which we can talk about. However, if I'm representing the seller, oftentimes you can't dictate the terms, but you can have some influence in the price. So what I would do in that case is I would get involved in an earlier stage of the agreement when the due diligence process is going on, and see kind of what's in the due diligence, and then try to negotiate for an equity purchase if I can. And if I can't, then to maybe compensate the purchase price for the fact that there's these tax savings for the purchaser and tax consequences for the seller. So there's an opportunity to kind of negotiate when you're on the seller side as well. And so that I think is kind of an overall theme here for these. And the one thing I would say is that there are there are practical aspects as well for why you may want to choose one or the other. So I mean, obviously what I discussed is practical, but those can be negotiated, right? And they're kind of a decision that you can make. A decision that you may not be able to make is the assignability of the contracts. And so when it's an asset purchase, essentially all of the assets, which are typically represented in some form of a contract, they have to be assigned to the new purchaser. So and that makes sense when, especially if it's a small company and it has a limited number of assets, or it has, a limited number of contracts and they're easily assignable. I did a case where essentially the assets were websites and other things like that, which in those cases, you don't really need to assign the contract. You can simply go onto the website and just change the payment information, and that's fine. But in other cases, you may have hundreds of contracts, and these contracts may very well have provisions in them that say that they cannot be assigned, or they cannot be assigned without the consent of the counterparty to that contract. And so in that case, it's really, really difficult to practically do an asset purchase agreement. And so in that case, you often rely on an equity purchase. And then there's, there are ways for the purchaser to get tax benefits out of that, which we may discuss, such as a 338H10 election or the F Corp election, or F Corp reorganization. But that, I think I would say, is kind of one of the key stumbling blocks that both parties have to be aware of. And that's why I say, I like to get involved in the due diligence process, because if I start seeing that there's dozens or hundreds of contracts, or if I start seeing provisions in the contract saying that they can't be assigned, then you know that you're going to have a problem with an asset purchase, and you should consider an equity purchase.
Yeah, look, Mick, that's a great, there's a lot there, and hopefully everybody listening can follow what Mick said. And if you have questions, we can try to help you out as well afterwards. But the other piece that you didn't bring up, but it's very much related to what you're saying, is situations that we've seen where there's some sort of certification that's been held at the corporate level, and that certification can follow through with the company on a sale, but it's held at a corporate level. And so the only way to maintain those certifications, and there are things like proficiencies with vendors, with government contracting and so forth. And so in order to novate these, they have to be done as a stock deal. And so, other considerations, not certainly that common, but definitely does come up. S Corp, C Corp, and then you talked about membership in an LLC. So, what are the implications for buyers and sellers in terms of, what type of corporation or legal entity they should have, and how does that drive or reduce their options in terms of even being able to do like a stock deal, for example? So if we typically see LLCs, S corps, and sometimes the odd C corp.
Right. Yeah. So and those are the typical forms that I see as well. And what I like to say is that really there's more than one way to skin a cat, and you can probably get to where you want to be, regardless of what form the two different entities are. And it takes structuring around it, right? And so what you find is that the choice of whether the target company is an S corp, is an LLC, is a C corp, that's made a long time ago, typically when the company is founded or shortly after that by the entrepreneur for whatever reasons at that time. And so by the time you get to a potential acquisition, it's kind of set in stone how it is, and you have to figure out how to work around it. Now the thing is the two easier ones. I mean, probably the easiest one is an LLC, and they're as you know, there are very few sort of legal requirements about who the owners are for an LLC or how LLCs are structured, and they can essentially be, the operating agreements can be however the parties want. And so that makes it a lot easier because you can purchase the membership interest if you're the purchaser, and you can, you can revise the operating agreements and do it to work how you need it to work. And so then C corps, in a way, they're easy as well, in the sense that they, what they are. There's a statutory framework for how they're supposed to operate, so they all pretty much operate the same way. And one of the issues with the C corp is that double taxation issue. So that's something that you'll need to work around. Now, the S corp aspect is probably the most difficult of the three, but it's not necessarily an impossible structure. And the reason why it's the hardest of the three is that it has a lot of requirements on who can be an owner of the S corp. And so depending on the identity of the purchaser, the legal form of the purchaser, what it is that the parties want, you'll have to kind of work around the S corp rules in order to get what both parties want.
Right. Okay. Great. Well, I mean, as is usually the case here, the standard answer, isn't it, of any attorney or good lawyer is it depends, or come talk to me. We'll talk about your situation. So, but I think that's a fitting response here to get more detail. So let's move on a little bit into this question around tax, sort of tax allocation, let's say, with respect to splitting between assets and goodwill, and therefore capital gains. The IRS wants, and similarly we're in Canada, so the CRA wants both the buyer and the seller to agree on what that split is. And so as a buyer, you can't put numbers that are favorable to you, and as a seller, you put numbers that are favorable to you on the same transaction. That there's a form. In the case of the IRS, it's, I believe, 8594 that needs to be filled out. I just wondered what your experience has been around any kind of contentions around the split of those, given that there's sort of opposing interests in terms of how that allocation is made. I think it's very easy when it's cut and dry, that you've got, if you've got a business where there's a lot of like inventory or something, and so there's value there, but in terms of like tangible assets, right? But in the case of these businesses that we deal with IT firms, primarily it's goodwill. There are really not much in the way of assets. So in some ways it does make it a bit easier, but sometimes we run into situations where there's hardware, servers, etc., and there's some value associated with that. So I just wondered what your sort of thoughts, comments were, and if you end up in situations where it's kind of hard to come to terms on that split between the two parties.
Yeah. And Heartland, as you mentioned, I think in most cases it's not all that contentious. And we put in, every asset sale, we put in some provision that either they make this allocation amongst the 7 different asset types, either they do it by closing or they do it sometime after closing, such as 90 days after closing. And what you do find is, yes, in certain circumstances, there can be conflict between the two parties. And in that case, what I've typically tried to do is both parties want to get the transaction closed. So, we try to put it as something that can be done post-closing, 90 days post-closing, and the parties work together in good faith to come up with some sort of a allocation. And if they can't do that, then they can bring in an independent accountant, and that accountant can essentially make the allocations. And so that's typically how it's been resolved. Now, one nuance I would say is that at least in the US, the parties don't have to 100% agree on these allocations. They actually could submit separate ones, but in that case, your chances of being audited by the IRS is gonna, skyrocket. Right. So, I don't think I've ever seen a case like that. I think they've always kind of come to a conclusion. But if there is contention, then ultimately, we bring in a third party and have them decide.
Touching on something you've already brought up on the call today, which is assignability clauses. And it was suggested to me recently, and I was curious about your opinion on it, that if there is no assignability clauses in a client contract, that the default of the law is that those contracts are indeed assignable. Is that your opinion as well?
I think so in general. So I would kind of start with that as an assumption. The issue there is that ultimately there's 50 states with 50 different laws, and so these contracts are governed by all sorts of different states. They might have different default rules. So you still have to kind of vet that and see what the state law that governs a contract and the transaction, see what that state law has to say about it. But I feel like in general, then yes, that is the case. That if there is no assignability clause, then it should be assignable.
Speaking of varying by state, that segues nicely into my next question, which is related to non-compete and non-solicitation clauses, obviously pertaining to employees that are included and the owners included in the seller's business. How enforceable are non-compete and non-solicit clauses, across the U.S.? And again, understand it probably does vary by state.
Yeah, yeah. And I mean, that's a great question because these non-competes have been a really hot topic over the last year. And Devin, you probably know that the FTC proposed some rules about non-competes and non-solicitations about a year ago. So I think it may have been April of last year, 2024. And so at that point, people were thinking that maybe these non-competes would just go away altogether, and just wouldn't be enforceable at all. But what happened is that one federal district court here in Texas, in particular, basically struck down the rule, and I think in Florida as well, a district court struck it down, and so the FTC could appeal that, of course, but I think under the current administration had said that they're more inclined to look at it on a case-by-case basis rather than having a blanket rule that applies to the whole country. So I think that the FTC regulations are basically dead in the water for now, and you have to rely on essentially what it was before those regulations. And there, what it is yes, it changes state by state, and some states are more open to the idea of non-competes, non-solicitations, and some states are very much against it. So California has a lot of requirements in order to make it one enforceable. Texas too, for instance, has a decent amount of requirements, and a lot of states basically have a kind of an economic philosophy that people should be able to work where they want to work, and they should be able to start businesses and do that. And so a lot of states require non-competes to be very tight, as I'd like to say. And but of course there are other states that are more open to it. Now, what does it mean to be a tight non-compete that would survive scrutiny? It depends on several factors. It depends on the state, and you got to kind of vet that in every deal. But in a lot of places, they look at kind of the time period. So you don't want something that lasts for the rest of your life, for instance. That would be too long. But I've seen 2 years, I've seen 4 years. So something like that is often acceptable. And then there's generally a geographic scope. And that geographic scope could be the United States. It could be a particular state. It has to be related to something. So you should probably be related to the business that's being acquired and where it operates. Though it could be global, that could be the geographic restriction. If it were global, though, then I would want to see a restriction in the particular industry. So I think that matters too, is an industry sort of restriction. You can't, if you're a purchaser, you can't really tell somebody that they can't ever work again for doing anything. But but maybe you can say, well, you can't work again in this industry for the next 5 years in the state of New York. Something like that could work. But so you see, there's all these factors. I think those are kind of the main factors that I've seen. And it just kind of depends, but you want to try to keep it within the normal sort of metrics that we see in the market.
In regards to the geography for these clauses, how does it work when you have remote workers that could be out of state or, for that matter, out of country? What region matters? Is it where the employee is located or where the company is registered?
Well, that's actually a really interesting question. And I think that's one of the things that's a very new topic that really has just kind of started after COVID, and there isn't necessarily a lot of agreement on. But I would say a couple of things is that, I had a deal that I worked on a little while ago where the people were kind of nomadic, and they were essentially software developers, and they were from Eastern European country, but they also had a presence in the United States, and the company operated globally. So, what geographic restrictions should there be there? It's really hard to say, and I think what we eventually came up with was it had to do with the geography where the company was most active, um, and then also kind of limiting it by that industry, that particular industry. So I think that that's where I would look at, is not even necessarily where the remote worker is working and not where the business is registered legally. I would look at where the business's operations actually are, where the revenues are, where the customers are, where it operates as a business. And then I would look even more so at the specific industry and what industry is that in.
Got it. And so just one more follow-up question on the non-competes, and we'll move on. But can you comment on the differences in terms of how owners are treated versus employees? And does the law look at those two separate groups differently?
Yeah, so I think it kind of does, and it depends on the employee. So an owner, especially in an M&A deal, they're clearly getting value for entering into this non-compete, and that's a big part of it, is what consideration is the person signing the non-compete getting, and the owner, it's very clear, and that that they're selling their company, and they're getting a lot of cash or equity in the new company or whatever else, and they're getting value. Then, as far as the employees goes, that's a little bit more murky because it kind of depends on whether the employee is a more senior employee or is a more junior employee. So, a more senior employee would have probably an employment contract. So, if there's an employment contract that this contract says you're employed for 5 years, and if we fire you for cause, this is what happens. If we fire you without cause, then you get some compensation. That is not an at-will employee. That is an employee with an executive employment agreement. And in that, I would say that a non-compete should be much more likely to be upheld. But if it's more of a lower level employee who does not have an employment agreement, then it's not as easy to say that just throwing in a non-compete is acceptable.
Makes sense. It's certainly an interesting topic. Lots of moving parts there, but appreciate the insights. So another question I had for you is just about silent partners. Can you talk a little bit about what rights silent partners have in the context of M&A?
Yeah, sure. So, all partners have some rights. So, whether, if the company is an LLC, then they're all, it's treated as a partnership, let's say, and they haven't made an election to be treated as a corporation, then they're all partners, in that LLC. They're members of that LLC. And then similarly, if it's a C corporation, they're all stockholders of it. And so there's fiduciary duties under general corporate law, for all of the members of an LLC and all of the stockholders in a company. So there's duties to act in good faith, the duties to act fairly, and non-negligently, and how these are applied changes in every particular situation and changes in every particular state. But I think the kind of takeaway that I always get is that there are these sort of obligations. And so if you are the majority member of a selling company, you have obligations to your minority members. And similar for any other party. And it's important to kind of deal fairly and transparently with these silent partners, minority partners. And if you can do that, then you've generally met all of your obligations to them. Where it starts getting, difficult is when, for instance, there's a lack of transparency. So there's no transparency, and then these silent partners are kind of surprised that there's a deal going on, and they feel, well, something fishy must be going on. So I think a lot of the problems can be avoided if you just kind of plan ahead and focus on transparency and fairness.
One of the questions that comes up from time to time is just this concept of and the considerations of subordination on debt. And a lot of the deals that we do, whether they go ahead with the SBA or not, there's a different story, but they certainly explore SBA loans, and in some cases, obviously go ahead with them. In other cases, they may use a different lender. But nonetheless, I just wanted to talk a little bit about the considerations there that I guess probably more so from the seller's perspective than the buyer's perspective in terms of the priority around debt when there's seller financing, and that a seller should kind of understand the implications there. So I just wondered if you might be able to speak a little bit to that.
Yeah. So, when I think about seller financing, I generally think of it as essentially an unsecured note. And oftentimes purchasers want seller financing. Sometimes they need it in order to finance the purchase, of course, but sometimes they don't need it to finance the purchase, and they need it because they want the seller to continue to have some skin in the game afterwards. And in that case, in those cases, I think it's hard for sellers to ask for a lot of security on their seller financing. With that said, people want security, and they try to get it, but you have to kind of be realistic. And definitely an SBA lender, any sort of lender that's an institutional lender, is going to have priority over the seller financing. And I think that that's something that you just have to keep in mind. And typically they'll have a UCC filing, and so they'll have true security on the purchased company. And so the seller, as they typically will hold a promissory note to represent their seller financing, and they have to be comfortable that they're at least going to be subordinate to the SBA lender.
Right. Yeah. Okay, good. And then the other thing that they can do that sometimes we discuss is, and it's difficult with IT businesses, but we've done liens in the past, and also in the cases where there's hardware, some kind of assets that are associated with the business, and then also personal guarantees, of course, as well. But
right, and personal guarantees I do see pretty frequently. So that can definitely be something that comes into play and gives sellers a lot more comfort.
Yeah, if the buyer is willing to do it, and that's the
right. Yeah.
If we kind of rewind the tape here about 25, 30 minutes or so, you had mentioned this idea of, you dropped the term F-Reorg. And I guess I just wanted to, without going into too much kind of complexity here, but see if you might be able to provide a bit of context for buyers and sellers around this concept. What are tax-free reorganizations, and kind of how are they used? We're seeing this more frequently used now, and so when should a buyer or seller consider using it? What are the considerations for both sides? So just maybe try to make this fairly simple for our group to understand.
Okay. Yeah, so I mean, a tax-free reorganization is generally preferred if you can do it. And there are specific rules in the code that if you comply with this, then you'll have a tax-free reorganization. One of them is an F-Reorg. And the reason, I mean, there's lots of reasons why they're used a lot now, but they need to be used in S corp reorganizations. So what you have is you have an equity sale in these, and so that for any reorganization, any of these, A, B, C, D, F reorgs, you need an equity transaction, not an asset sale. But what the F reorg can help you do is get the tax treatment of an asset sale. So that's very beneficial to the purchaser. And in particular, an F reorganization can also allow the seller to have some sort of minority interest in the new company, the acquiring company. So you often see private equity companies and the investment group types use F reorganizations, and the way they'll structure the deal is that the seller will get some amount of cash and they'll get some percentage interest in the company going forward. And so the F reorganization allows you to do that. And that meets, what the seller wants. It also has kind of the tax advantages for the buyer. And so that, that can be used. There are other ones like the 338H10 election that can be used. But essentially what you're kind of doing with these is you're trying to get the best of both worlds. You're trying to get an equity style or a sale of equity, but the tax benefits of an asset sale, and also kind of the tax deferral of a reorganization.
Yeah, so these are the benefits from the buyer's perspective. What are the implications for the seller?
Yeah, well, for the seller, so the seller will have an easier tax easier tax position, for instance. So because they're actually still selling equity, and so they'll have a much more simpler one. It's much more likely to be capital gains treatment, and so there's some benefits to the seller as well. But a lot of the benefits are these non-tax benefits, so being able to sell the entire equity of the company and transferring any sort of liabilities and just kind of being done with it. And that's a big advantage, for instance. And not having to assign every contract and things like that. So it has a lot of benefits, both tax and non-tax.
Okay. Yeah, you're right. We do tend to see that structure coming through more with what we'll call our financial buyers, so private equity groups and so forth. So more so than some of the smaller strategics.
Yeah, exactly. And that's what I see too. I mean, the smaller strategics, I think, first of all, the tax situations are probably not as complex. The number of contracts they have are not as complex. The business itself of the seller is not as complex. So I think, one of the things about doing reorganizations is there's going to be a lot of legal time there, and time is money. So definitely for smaller strategic buyers, it may not be worth it to do one of those more complicated transactions.
We're seeing more buyers that are coming through us anyway, interested in US-based MSPs, IT firms, and they're coming through from, we're getting a number from Europe and getting some from Australia, Mexico, and I think we've had Asia as well. And so my question to you is that there's always this sort of hesitancy around international, that we don't understand their laws, we don't understand what we're signing up for. How can we trust them? Are they going to be able to provide the same level of support? Are there language issues? All these types of things. But if we just talk about from frankly, a financial perspective and a legal perspective here, in terms of what recourse does a seller have with an international deal, international buyer, and ultimately, of course, they're most concerned about getting paid. So what recourse do they have in terms of getting the payments that are due to them, including the earnouts? What are their options, and how sort of difficult is this? Is there more fear around this than there should be, or what are your thoughts?
Well, I think a lot of the fear is actually legitimate, because at the end of the day, the buyer is in a foreign country, and it's going to be hard to enforce your rights as a seller. And so there are things you can do to try to mitigate that. And the best thing that you could really do in practice is just to do the due diligence on the buyer and get comfortable with the buyer. So I think practically that's the best and first thing to do. But aside from that, kind of from a legal perspective, there are things you can try to do to protect yourself. So if you can have governing law and forum to be in the United States, that would be protective.
Right.
And if there are things for earnouts, I mean, obviously, if you can get as much cash as possible up front, that's protective. And then if there are things such as earnouts, maybe they could be put into an escrow, or maybe there could be some sort of guarantees or even credit support, like a letter of credit. Now those things I think are pretty rare, but I think it's worth kind of considering and seeing what you could do, because ultimately, if the buyer has the cash, and if they have an escrow for the indemnities, for instance, then they're kind of in the driver's seat, and it's up to the seller to essentially sue or go into arbitration. So I think when you're getting into the deal is when you could try to protect yourself the most, by, kind of, as I said, have the governing law forum here in the U.S., try to have arbitration maybe, and other things that might protect you.
Right. Okay. No, look, those are all good suggestions. And as you said, I mean, as cash is king, right? So some people look at the transaction saying, well, I don't ever expect to see the earnout piece or the seller financing. So if I get my 80 or 90%, and everything else is sort of a bonus. So if they look at it that way, then chances are it'll all work out. But of course, there's no guarantee, and so at least they go into it knowing that they've got the vast majority of the deal in hand.
Right. Exactly.
If we could talk a little bit here to this NWC, networking capital issues that can come up, and talk a little bit about what you see. Generally speaking, from our side, we used to see that networking capital was clearly brought up in stock or share sales, and not really brought up so much in asset transactions. Increasingly, we're seeing groups bring it into asset-based transactions, or at least part of the negotiation process. And I guess I was curious what your experiences have been and are with respect to applying networking capital versus the alternative that we've often done, which is simply a true up around alignment of expenses and revenue, such that expenses are aligned with revenue as it's earned. So if there's deferred revenue, in other words, that's revenue that has been collected in advance of delivery, that be credited back to a buyer for periods that are post-close. And if, to the extent that there are expenses that have been prepaid for periods post-close, that becomes a credit for the seller. And so that there's this adjustment post-close that's done that kind of creates this true up. And so I just wondered what your experiences have been, and if you could talk a little bit about that.
I like the post-closing adjustments, and that's pretty much that's the vast majority of what I've seen, and I think that this is probably the reason why. So networking capital as a concept, and as a concept that is in the deal and is included as part of the sale to the purchaser, that makes sense when you're purchasing a company. So when you're purchasing the equity, stock or membership interest, whatever, that makes sense because the purchaser is purchasing a company, and they need net working capital. Now, when they're purchasing assets, I don't think that just kind of conceptually it makes as much sense. And in that case, I think these sorts of true ups that you're talking about, those make a lot of sense. And I just worked on a deal not too long ago that had these true ups. There's plenty of deals that have them because customers may prepay. Their expenses may be prepaid, as you said. So all of these sort of prepayments or pre-delivery revenue, the deferred revenue, they happen in most cases. And so I think there you want to identify what they are, and you want to do a true up like you said. So the deferred revenue should be credited to the purchasers. Something that's more like a prepaid expense should be credited to the sellers.
Yeah, look, I mean, it's great to hear another data point because that has historically been our experience, and in general, our recommendations as well. Just more laterally, we've seen that there have been more requests for a net working capital adjustment, and so it obviously creates another point of potential friction in the deal, and obviously we have to try to navigate that, and it's curious to get your thoughts as well. So
just a follow-up question on that one, actually, Hartland, if you don't mind. I'm curious is there any reason why it shouldn't be possible, or it shouldn't be allowed or permittable, I suppose, to use the net working capital adjustment in an asset deal? I mean, I understand it doesn't really make sense conceptually. I think we're on the same page there, but we still seem to have some buyers who are quite insistent upon it. What are your thoughts on that?
I mean, I think you can do it. I don't think it's something that is a non-starter or just should be avoided altogether. So I would assume in that case, Devin, the buyer is purchasing probably all of the assets or almost all of the assets, and is essentially treating it like a purchase of a business, and maybe is structuring it as an asset sale for legal and tax purposes. And in that case, it makes a lot more sense for them to say, well, I need some working capital in order to run this business after I buy it. So I think in that situation, it can be warranted. I think then, though, from the seller side, I think you're going to have to look at a number of things. Net working capital typically changes quite a bit, so you don't want it necessarily to be some sort of an average over the last 3 months, 6 months. I mean, you could, but you have to see what the variability of that net working capital is. If you can get a specific number, that is better. So I would kind of look at those factors, and I think that if I was representing the seller, I would tell them that they want net working capital. This is more usual in a stock sale, and I think that you should try to get a higher purchase price to compensate. Now whether that works or not, I think it's a fair thing to consider.
Yeah, and I think the other thing that we're seeing too is sometimes buyers, especially if they're using like SBA financing, they're asking for the net working capital because maybe they don't have as much cash to inject into the business themselves, and they're hoping to tie it into the SBA loan. So I think that's part of it too. But I appreciate your insights on that. It is certainly something that we're seeing coming up more and more.
Okay, excellent.
Mick, thank you so much for spending the time with us. We covered a lot there, and I'm sure that we could come up with a lot more questions. And if we had Q&A here, there would be undoubtedly more questions for you. But very much appreciate your time. I hope if you're listening to this recording that you got a lot of value from it. And thanks for participating. Feel free to reach out if you have any questions for Devin or myself, and we can put you in touch with Mick if you'd like as well. So Mick, with that, have a great rest of your day. Thank you so much, and we'll speak soon.
All right. Thank you both very much.